Hello, everyone, and welcome back to the Digital Literacy eDiscovery mini-series. Absolutely delighted to welcome back our collaboration partner as well, which is Enhanced Litigation Management Solutions. And you're going to hear from all of those folks today, from Kate, from Kira and Sam, on the eDiscovery process. Just a fascinating process. And this is going to be a really, really practical deep dive into that as well. So I think you're going to find it not just interesting, but really actually fascinating in terms of the content today. This is episode 2 in the mini-series. So if you have missed episode 1, it is available as a video and a podcast. We certainly encourage you to go and have a listen to that. And this is episode 2 in 5. So we will have another 3 episodes, and we will remind you about that at the end as well. So with all of that being said, I'm going to hand over to you, Kate. I'll go off screen. I'll be back at the end, but I'll be listening intently in between. Thanks very much again, everyone, and welcome to everyone as well.
Thank you so much, Terry, and for saying that our process is a very exciting one. We all love the eDiscovery process, so I'm hoping you will all enjoy it with us today. I would say at Elms that we are process freaks, so any process we can find, we will grab it and run with it. But this particular one is the one that is the most amazing to us of all. So let's get cracking. But before we start talking about our wonderful process, we just want to cover off when you would actually use eDiscovery software and consulting services. Now, there is a solution for every sized matter. Back in the good old days, you would just use eDiscovery solutions for really large matters, but that certainly has changed. So now we are seeing small to large and anything in between. So for something like a smaller matter, so about anything under 1,000 documents, we wouldn't really recommend that you use a litigation database. But what we would say is that you could use a hyperlink spreadsheet or a fully text searchable PDF solution. And the guys are going to run you through those particular solutions in the next set of our series. Anything that's over 1,000 documents, and particularly if there is emails within that set and those emails have attachments, then we would recommend you use litigation database. And the process that we are running through today is going to assume that you need a litigation database. So you've got over 1,000 documents and they contain emails and attachments. Now we follow these same processes with any size matter, no matter whether it's large or small, but we just scale the level of information that we require to the size of the matter. So everybody, this is our lovely eDiscovery timeline that we follow, which pretty much lines up with your litigation process. So it's a mini process within the entire litigation process. And our process starts from the end of pleadings and continues right through to an e-trial if we can convince you to do one of those things. So for every step in the process, you can add a bit of tech in to help you work more efficiently and effectively along the way. And the timeline sets out the steps we follow right from identification of document sources through to trial. And we're going to give you a brief overview of some of these components in our presentation today. In addition to the processes that we follow, we use specialist litigation databases, and for us, that's eDiscovery, and we manage the disclosure process with that technology and through to preparation for trial. So today I'm going to cover off the identification of document sources stage. Sam's going to take you through collection, preparing a document management protocol, setting up the litigation database and processing the documents. And Kira's going to cover off what we typically do to prepare those documents prior to giving them to the legal team for the legal review process. And then in the next session, we're going to cover who you're going to need for your legal review process and what are the different methods for legal review, so you can also understand that. So let's get cracking now and understand what our first process is, and that is the identification of document sources stage. So the identification of document sources stage is really, really important because it's going to set you up for every stage that follows it. But before we start to actually identify the relevant document sources, we firstly need to understand the claim. So in order to do this, we of course have to read the pleadings. Now, reading a pleading when you're a technology person can be quite challenging, especially if it's hundreds of pages long and really formulaic. So when we read a pleading at Elms, we read it a little differently to a lawyer. So firstly, we would get out all of our coloured highlighters and get them all ready to code pieces of information that we're interested in. And what we are really looking for is key witness names for both your plaintiff and your defendants, any sources of documents that are listed. So often, say, for example, if you had a construction matter and the parties were using any software like AConnect or ASite or Project Center to share documents between them, this type of software would be listed in the pleading. So we're looking for software names so that when we go and talk to the client, we can search for those bits of software and find them and locate them and collect out of them. And then we also want to highlight the types of documents that appear in the pleading. So if there's emails or board papers or letters, all those types of documents that we would look for, because we're going to use this information to inform our discussions with your IT team or the client's IT team during the identification of document sources meeting. So we're going to highlight any dates within the pleading so we can determine the date range, the start and end date for the claim. This is going to help us to narrow down the documents that we're looking for when we're just prior to collecting the documents for you. And then we, of course, highlight any particularized documents, which we want to tag up in the litigation database so everything is ready and organized for you to go once you get into your litigation database. And then the next step is for us to have a chat to the legal team so that we can understand what the legal issues are in the claim, if there's any time frame or date range involved in the case that we might need to go a little bit broader on our date range. Sometimes when you're collecting, you might go a little bit broader either end just to make sure you've got everything, or if you've got any potential date issues, you want to just collect a little bit broader each side so that you can minimize the risk of not getting everything you need. We want to know who the key players are from the legal team's perspective, and also any witnesses that haven't been mentioned in the pleading but are also really important to the claim. And then finally, we'll want to know from them what types of documents they think are likely to respond to the claim. So we want to make sure that we note those down so that when we're talking in the next stage to their client, we can understand the types of documents that we are looking for. So then the next thing we need to understand is to identify the sources of documents that might contain relevant documents. So this would normally involve a meeting between the legal team that's instructing us, their end client's IT team if they've got one, or directly with their end client if not. And during this meeting, we're going to ask the legal team and the client questions along the way about which document sources are likely to be relevant and therefore need to be collected. And we're going to identify any risks along the way and work out a solution with how we mitigate them. So what we are seeking to identify is what is the technology infrastructure like at the time of the project. And this is going to help us to understand the general technological environment at the time. Then we want to know all of the document sources that were either electronic or hard copy. And some examples of this might be, we're looking for laptops, personal computers, desktop computers, servers, the cloud database, the list goes on and on and on. So we want to identify all of those document sources in that particular meeting. And then we want to know what types of software that the witnesses would have used on the project at the time. So this is going to tell us if there's any odd file types that we need to look out for and deal with in a different way. And an example of this would be a 12D model in a construction matter. So these actual 12D models can't be viewed in a litigation database. So we would need to disclose them in their native original format to the other side so that they can view them correctly. And then, of course, if we're going to court, we'd need to make sure that they would have an appropriate software to be able to display these 12D models if they're relevant to the claim. And in addition to that, you don't really want your client to pay to store these types of files in a litigation database because they're normally really, really big in data size, and therefore they cost you a lot of money to store throughout the matter. So we're going to work out a solution to deal with these files outside of the database, but still maintaining their integrity. Then the next thing we need to know is how and where the documents are stored and in what locations. So for example, if you say to your client, oh, where have you got the documents stored? And they say, oh, they're on the H drive. Then what you need to understand is, do they have multiple offices? So if they have a H drive in Brisbane, do they also have a H drive in their Sydney office? And if they do, then you might need to collect from multiple locations throughout the process. The next thing we look for is their backup policies. So we want to know what policies were in place at the time of the project. And this would inform us as to whether that you potentially have any missing documents in a particular date range. So if something's gone wrong with a backup, we want to know that up front. And we also would like to know whether you need to collect from backup tapes. Now, I'm not sure if anyone's ever done that before, but it can be really costly depending on what format the backup tapes are in. So if we can avoid that process, we try to. Sometimes unavoidable, but yeah, we just need to identify that up front so that if we can avoid it, we try and certainly do that along the way. And then the final piece of the puzzle, sorry, not the final, nearly the final, is archiving procedures. So we want to know what procedures were in place at the time. And this is going to tell us, depending on what type of archiving software they use, whether your costs may increase in order to collect from the archiving software, or whether that software manipulates the documents on archiving, which means it might cost you more money to get them objectively coded down the track, particularly the document dates, or potentially it could render the deduplication process useless, which will mean the lawyers have to review duplicate documents in the database, which we are also trying to avoid at any cost. And then finally, we want to know if there is any upgrades that have taken place since the project. So if the project was many, many years ago, the software that they used at the time may no longer be usable or available to us. So if that's the case, we would just need to develop a solution to collect those types of documents and get them reviewed in another piece of software. So we're just looking out for anything that has, you know, if they used a project database at the start of the project and that database doesn't exist anymore, we might need to recreate that database environment so that those documents can be reviewed by the legal team. So now that we understand all of the software used and how they've stored their documents, the next piece of information we need to know is how they structured their documents that they stored on their network drive or in their database. Now, this is really, really important to understand. It can save you thousands of hours of times locating documents once they're in the litigation database. We're going to take your client's structure that they had sitting on their folder structure, and we're going to recreate that in the litigation database so that when you say to your client, where is the board materials folder, they can direct you straight to that folder in your litigation database, which is going to save you time and money trying to locate those documents. Next, we need to understand if they used a template folder structure or did everyone just do their own thing and save documents wherever they like. We want to know if their documents are organized nicely or completely disorganized. If there is a really good template structure, you're going to be able to easily locate documents in a consistent manner based solely on the titles of the folders. For example, if there was a folder called board materials, then you would expect that to contain board reports, board agendas, board minutes, and any documents that are associated to the board materials. So ideally, we like the folder names to represent exactly what's in the folder. If this is the case, then they're easy and predictable to find, and it makes the process of locating documents more efficient. But sometimes on the face of it, that folder structure will make no sense to you. So when we're talking to your client, we want to identify whether the structure they've created makes sense to them, and then we get them to explain that to us so that we can replicate that structure in the database and find the documents easily. Most folder structures have some sort of order. It may just not be obvious from the face of it until you have a discussion with your client. And then another area which is really important for us to understand is whether the client has saved all communications and documents that go between them and the legal team into a folder, and if so, what is that folder called? So once we have that information, we can isolate those documents in the database and have a senior legal team member review those documents for privilege. Here's just a little tip for everybody. If you're asking your client to create a folder for the dominant purpose of litigation, please get them to name it something obvious like legal claim. That way, it's going to be really easy for us to locate in the database and really easy for the junior team members or the paralegals reviewing documents to identify them as potentially privileged by the name of the folder. Some law firms instruct their client to give the folder name something like Project Missile, some sort of secret name. And the problem with that is it's not obvious in the database that that folder was created for the dominant purpose of litigation. So if you can name it something obvious, it will be easy for everybody to find in the litigation database. And then finally, we're also looking to see if the documents are named consistently, which again is going to help you to easily locate documents and get across the matter really quickly. If the titles to documents are not consistently or accurately descriptive, you're not going to be able to rely on the title for searching purposes. Now, I can tell you at Elms, we love a good document naming convention. In fact, I've written quite a few stories about document naming conventions, and I could really spend hours and hours talking about the importance of document naming. But of course, we don't have time for that today. So if you need further information or advice in this area, please let us know and we can design something specific for you or your client. Because if you name your documents effectively, they will be a lot easier to locate whenever you need them down the track. So now that we have worked out where all of your electronic documents are, the next bit of information we ask you is your hard copy documents. So do you have any? And if so, where are they? How are they stored? Are they in any order whatsoever? And are they indexed accurately? So if they're indexed well, it's going to be really easy for us to go in and locate the actual folders we want and just pull back those documents that are likely to be relevant. If they're not indexed well, you're going to need to pull back everything, which is going to increase your costs. So if your client tells you not to worry about the hard copy documents because there's going to be an electronic version, we would recommend that you just want to make sure that those hard copy documents don't have handwritten notes on them, because these could of course be the smoking gun to your case, which is sometimes the case, and be really relevant to the claim. So we want to make sure we collect them. So make sure you don't overlook your hard copy documents, even though you think you probably already have an electronic version of them. So now we understand everything we need to know about the documents. So we need to sit down and collect the documents. So we're going to have a chat to your legal team and we're going to work out what we want to collect or not collect. Now, sometimes there can be multiple strategies in play here. For example, if you have a really short time frame and targeted searches, you might over-collect documents and use the power of the database to reduce the volume for review. But if you have a litigation that is going to go for many, many years, you probably want to identify documents that can be excluded from the collection up front, as opposed to just collecting everything along the way. So here's a quick, an eDiscovery provider can help you to intelligently target and collect only the documents you need so that you can avoid overcollection. But one easy way to reduce the volume of documents is to review the folder structure on your client's network drive or in a database and identify documents which definitely don't need, that you know are not relevant and therefore don't need to be collected. Here's a quick case study to show you how the effect of identifying folders that should not be collected was really effective. So we had a case a few years back in which most of the project documents were relevant as the claim was really, really broad. So we asked the legal team to identify folders that were definitely not relevant, and they identified multiple folders. And that folder contained 28 gigabytes of data, which on the face of it, you would think did not contain a lot of documents. But in this particular case, it contained around 124,000 documents and totaled just under 560,000 pages. So that number of documents would take a lawyer around 2,000 hours to review and about 276 days of legal review time, which is, of course, is enormous. And it would cost around $363,000. So the message here is, instead of trying to identify folders that should be collected if you've got a really broad claim, is try and identify folders that should not be collected, which might be able to reduce the number of documents to be reviewed and, of course, therefore the cost of that legal review. So the next piece of information we need to get from the IT team is a list of all the naughty kids. So we want to know who the witnesses are, whose documents might not be exactly where we think they should be or the IT team thinks they should be. These people don't usually follow the rules set out by IT, and IT will be able to give you their names. They'll be in a drawer, their top drawer on their right-hand side. They'll know exactly who these people are. They don't normally save documents in the correct place, and they don't normally follow the structured naming convention. So their documents are going to be harder to find in your litigation database. You're going to need to rely on your advanced searching skills to try and work out how they titled the documents in order to find them. Now, this is going to take a bit of trial and error, and with these particular bits of software, they do take quite a bit of training. So we're going to help you understand how you conduct your advanced searches so that you can find all of the information that you need to find. And with these particular naughty kids, we're going to deal with their documents a little bit differently. Once we identify who they are, we can then work out a way to effectively identify and collect all of their documents as well. And lastly, we need to identify any potential risks associated with the documents and find some solutions for how we might mitigate those risks. So the types of risks we are looking for is altered metadata in documents, and specifically the document date of the document. If the document date's busted, this is going to affect two things. Firstly, it's going to affect the searching across document dates in the database and your ability to sort those documents chronologically. And secondly, it's going to cost you a lot of money to correct the problem. So in order to correct the problem of bad busted document dates, we need to manually code these documents, which means a human being needs to sit down and go through every document in your database and check that the document date is correct or change it if it's not. This is really, really time consuming and costly, and we try to avoid it wherever possible. So if we can find these issues up front, we'll try and correct it at the collection stage as opposed to correcting it once it gets into the database. Another risk we are looking out for is anything that could affect the deduplication process. So, for example, some email archiving systems alter the metadata of an email, which means that the software doesn't recognize the document as an exact duplicate. And what that means for you is that your legal team may need to review duplicates of emails, which will increase the cost of legal review and be extremely frustrating for the legal team. So if we can catch these risks early, we can try and mitigate the problem upfront and reduce the cost of fixing the issues later on down the track. So now that we have all of the information that we need to continue to the next stage, we prepare a document identification questionnaire, which you can send out to all of your witness with your disclosure statement, or alternatively, you could use it to interview the witness about their documents so that you can properly understand their personal document landscape. The questionnaire is designed to prompt witnesses' memory. It's really hard to remember details about documents you produced from projects that happened many, many years before. So the questionnaire is going to help them to reacquaint themselves with what existed at the time, and it also helps them to remember all of the document sources, not just the ones that they use most frequently. So that's it for me, everybody. I'm going to hand over to Sam now, and he's going to have a quick chat about collection and lots of other things. So thank you, Sam.
Okay, thanks, Kate. So I'm going to guide you all through the steps from collecting the documents through to setting up the database and processing the documents into it. Okay, so now that we've identified the documents we need, it's time to collect them. There's three main collection strategies that would typically be used. You could do a full forensic collection, you could get your client's IT team to collect, or you could get your client to collect. When might you use each of these? So a forensic collection is the least common. You'll usually use this if you have a specific device such as a phone or a laptop, and you want to collect every single scrap of information stored in it for evidentiary purposes. So this is the most in-depth and expensive way to collect data, and you'll often end up having to sift through mountains of not relevant information just to find exactly what you're looking for. So you should only really use this method in situations where you absolutely need it. For your client's IT team, typically you would use this when you're doing a company-wide collection that would involve special admin privileges. So for example, if you were collecting the emails of 16 different employees, instead of going to each person individually, your client's IT team should know how to just package all of those up for you. And the last is collecting directly from your client. So you might use this for a smaller collection of your client's emails or folders on a network drive. And when your client has access to all the documents, you can just talk them through how to collect them in a few steps. Your eDiscovery provider can guide you through what the most appropriate method to reduce the cost to your client is for collection. If all you need to do is collect someone's email inbox, then it might not be appropriate to do a forensic collection. Maybe you could just get on the phone with them and talk them through how to package up their email inbox for you. So now that we understand the landscape of our documents from the previous steps, it's time to prepare the protocol for exchange of electronic documents. Often we refer to this as a document management protocol. So the protocol is essentially the rules of disclosure. When you first heard the word protocol, I'm sure half of you just fell asleep. Who cares? Let's just send our documents off to the other parties in whatever way is convenient, right? Wrong. So it's really, really important that all parties agree on and follow a good protocol so that you can minimize document management and technology costs throughout your matter. The primary purpose of this protocol is to ensure that each party is able to access the other party's documents in a technology neutral way. And what I mean by that is whatever litigation database you choose, whether that's Nuix Discover, Relativity One, Disco, Reveal, or any other product, you should still be able to view all of the other parties' documents in the same way. In the long term, all of the parties should be able to provide documents in the exact same format for the purposes of an e-trial. There'll be a separate technology to run an electronic courtroom, which will be negotiated at the appropriate point in time. So what exactly is in the protocol? The protocol will set out the standards, particularly for the format of the documents to be exchanged, the numbering on those documents, the fields and data to be exchanged, what you need to do if you need to add or update extra documents, and who is responsible for the cost. So now we've collected our documents and we've agreed on a document management protocol. We can then set up the litigation database in accordance with that agreed protocol based on everything we've learned so far about our matter. Elms have our own unique database template over many years working in law firms and eDiscovery providers, and it's designed to bring some structure back into the documents. We update this template frequently as we learn with each matter, and your eDiscovery provider should have their own database template that they can get you started with. So what you don't want is to receive a litigation database with all of your documents in a giant list and just be told to go ahead and review the documents. The purpose is to fit the technology to your matter to make the life easier, not to fit your matter to the technology. So you should at least be able to have the ability to code documents to case issues, chronologies, pleadings, witness statements, expert reports, and lots of other things. So for example, we recently had a matter where the lawyers needed to keep track of witness statements across multiple trials for the same matter. What we did was build this into the database so the legal team could quickly identify at a glance what witness statements each document was in and which trial, as well as be able to quickly tag documents to any new witness statements that we're making. So our template will enable you to tag handwritten notes and hot documents as you code for relevance as well. We've also developed templates that will enable you to view documents in chronological and reverse chronological order, maintaining host attachment status. If you don't know what host attachment status is, I'm going to explain this shortly. By document ID, as if you were viewing your documents in a list of documents as required by your protocol, or by file path, so that you could see the documents in the order they were in on your client's network. Basically, everything you'll need throughout the litigation process should already be in the database before you get access. If there's something else you need along the way, your eDiscovery provider can just add it into the database for you. So once the database is set up, we can now start the processing stage. This is where the database really adds value and removes a lot of tasks which would need to be done manually if you are not using a litigation database. So there are a lot of technical tasks which are completed so that when you get access to the database, everything's ready to go. Firstly, the software is going to remove any exact duplicates from your document set. This is not always an exact science and is dependent on how your client stores documents as to whether this is 100% successful. You could have two documents side by side. When you look at them, you can say these are obviously duplicates, but on a technical level, for whatever reason, they might not actually be duplicates. So if the software isn't able to determine all of the exact duplicates, we do have a few tricks up our sleeves to identify them in another way. The software will then make everything searchable, or OCRs, the documents. OCR stands for optical character recognition. Depending on the quality of the documents and the types of documents present, OCR may not be 100% exact. This can be affected by the age or the quality of the scanned documents. If they've been scanned multiple times, the OCR software can get confused. And for example, it might see the number 8 as an S or something like that. So if the OCR software is not able to effectively OCR the documents, You may need to rely on other fields in the database or think outside the box of how you're going to search across those documents. Your eDiscovery provider can assist you with searching so that you're able to locate all the documents efficiently and effectively. The software is then going to separate the emails and attachments and converts everything to PDF just prior to stamping each individual page with a unique document ID, so that way the legal team can refer a witness, barrister, an expert, or the court to a particular page in any of the documents. The software is then going to extract all of the metadata from the documents. For example, the date of the document, the title of the document, the type of the document, and for emails, the tos, the froms, the subject of the email, and the date it was sent. It's going to place all that information into the appropriate field in the litigation database, ready for you to search across it. Please keep in mind that there are often problems in the processing stage. Some are going to be big and some are going to be smaller. So if you do come across a problem, please be nice to your eDiscovery provider, as this might be a problem with the data and not with them. They will be able to work through a solution with you. Documents or data are always different as the environment they were produced in is different. So like I said before, the same email in two different locations can be technically different because of how your client's software treats those emails. This is sometimes why the deduplication technology doesn't remove documents that you think it should. Your eDiscovery provider should pick up on any problems and fix them in the quality checking stage, but there might be some issues which can only be picked up when the legal team are reviewing those documents. So if you do see something you wouldn't expect in your document set, chat to your eDiscovery provider who can find a solution for that problem. Okay, so in the previous slide, I talked about separating emails from their attachments. eDiscovery providers often speak a different language, so we thought we would do a bit of eDiscovery 101 while we're here. You will often hear us refer to the host attachment relationship or source attachment relationship when we talk about documents. Let's have a quick look at what that is so you can understand the terminology. So in the processing stage, the software separates emails from their attachments so that they're individual documents in the database. This is going to help you locate and search for all documents in that database and is also a requirement of most document management protocols. The database is then going to recreate the connection between the email and its attachments so that you can always read everything in context. We refer to this connection as a host attachment relationship, a source attachment relationship, or a parent-child relationship. And you'll often hear us referring to documents grouped this way as a family of documents. If you have any document with no attachments, or if it's just a standalone, we'll call it a standalone or a single document. In the processing stage, we also talked about stamping each page with a unique document ID. So let's now explain what the Australian document ID structure is so that you can understand where it came from originally. Each page of each document is going to be uniquely identified by a document ID so that the legal team can refer to a particular page when required. This is going to reduce confusion and make it very clear what page in which document you're referring to. So the document numbering format has 3 or 4 levels depending on the matter. In Australia, the document ID is going to follow this structure most of the time, this AAA.001.001.0001, where AAA is the party code, which is going to identify which party produced those documents. For example, if you're the plaintiff, maybe your party code is PLA, so all of the documents you produce is going to have PLA dot at the start of it. The next level after that, 001, is a 3-digit box number. So this is just kind of a callback to hard copy days where all the documents were in folders and boxes. And even though we're a lot more electronic today, we still follow this same structure for all the documents. So for hard copy documents, every box of documents is going to be allocated a box number. And for electronic documents, the box number is going to be a virtual box number, which could indicate a particular witness or the source of those documents. The next level is a 3-digit folder number. So for hard copy documents, every folder within each of those boxes will be allocated a folder number. For electronic, once again, it's a virtual folder number, and it could indicate a particular date range for a witness or the folder structure of the document stored by that witness. And finally, the last level is the 4-digit page number. So the first page number for each document is going to be the document ID for that whole document. And you can use that to refer to the document in witness summaries, statements, expert reports, submissions, and in the trial or e-trial. The protocol is then going to set out where that document ID is going to be placed on each page. And usually that's going to be in the top right or the bottom right-hand corner of each page. Okay, so next I'm going to hand you over to Kira, who's going to talk to you about preparing your documents for review.
Thanks so much, Sam. So I'm going to be taking you through the process of preparing the documents prior to legal review and what that looks like in a nutshell. So when documents are stored on your client's network, they would usually have some sort of order. When we put them in a litigation database, they lose that structure and they can become a bit of a jump. So it's our job to put that structure back into the documents so that you can understand how they're ordered in their original location. So sometimes the folder structure could be on a network drive or in SharePoint or in a database, and it can give you a lot of information about the documents sitting in that location. So that's where we try to add that information back into the database. So when we process the documents in the database, we use the metadata to group documents into broad categories like emails or Word documents and date ranges. So for those of you who don't know what metadata is, it's essentially information about a document, such as a title, the last modified date, document type, and tos and froms for emails. So in addition to the metadata groupings, your eDiscovery provider should then go about adding some structure back into those documents by grouping key document bundles together, recreating the file structure that existed on your client's premises, and locating potentially privileged material. So once that process is complete, your eDiscovery provider then presents this information to you in a way that makes sense and that is easy to navigate. So what we are trying to help you understand is that eDiscovery is so much more than just uploading the documents into a database. So the next few topics will briefly discuss how an eDiscovery provider can add enormous value to your litigation database. We won't have time to go into the detail on those items today because they're a session in their own right. But if you are interested to hear more, please contact us and we can design a session specifically for you. So firstly, it's really important to keep your documents organized when they're in the litigation database. The legal team should be able to locate any set of documents with the click of a button. So for example, any documents referred to in the statement of claim or a witness statement or any other document disclosed by another party. So if you keep everything organized and structured from the start, it will save you hours of time later on. Next is the key document bundling process. So this process is very effective to assist the legal team to understand the story of the documents quickly and in context. So for example, if the legal team can review all of the minutes of the board meetings at one time, they will get across the story a lot quicker than if they were just reading all of the documents chronologically, coming across the minutes in between all of the other documents. Next, we have the privileged document analysis. This process assists the legal team to quickly identify potentially privileged documents and reduce the risk of their disclosure. And the final process we conduct prior to handing the documents over to the legal team is to reduce the volume of documents they need to review. So in a report conducted by the Rand Institute for Civil Justice titled "Where the Money Goes, Understanding Litigant Expenditures for Producing Electronic Discovery," they identified that the major cost of disclosure process was, of course, legal review at 73%. So your eDiscovery provider should be able to assist you to identify documents which are clearly not relevant to your matter and remove them from the legal review and that litigation database, which will therefore reduce your cost. So now let's jump into 3 case studies: a large construction matter, a medium-sized litigation, and a small email inbox review, so that you can understand how by reducing the volume of documents, you can reduce the cost of the disclosure process overall. So this first case study demonstrates the benefits of junk culling or removing documents which are completely not relevant to your matter. This was a large construction matter based in Queensland, and we identified and collected approximately 1.9 million documents which were relevant to the claim. These documents came from multiple sources, including emails, network drives, databases, hard copy documents, and AConnex, which is a construction database and online data room. So after processing, the deduplication then removed around 720,000 documents, leaving around 1.2 million documents to be reviewed. ELMS then went about identifying and removing documents which were completely not relevant to the claim, which ended up removing around a further 198,000 documents for review, which left around 1 million documents for the legal team to review. So overall, whilst that's still a large number of documents to review, ELMS reduced the initial volume by 52%. This is before the legal team even had to review the documents. So now let's put some cost around this. So we will further reduce the volume of documents for the review by identifying entirely irrelevant documents. So for example, your Dan Murphy's emails, NRL football teams, things like that. And this removed from the legal review around 198,000 documents, which was around 895,000 pages. So that's a lot of reading. If the legal team to review these documents, it would take around 3,315 hours or 442 days at a cost of $596,000. So as you can see, this was a really good result for our client. The second case study we're going to take you through is a litigation matter where the law firm had a really short time frame to complete the review and their disclosure of their client's documents. So the law firm's client was not engaging in the collection process. The communication between the IT team and the legal team had broken down, and the law firm engaged ELMS to assist with the identification and collection process and translate that IT speak to legal speak and vice versa. So ELMS worked directly with the law firm's client's IT team to identify the relevant document sources and collected the documents. In order to minimize the disruption to the client's business, ELMS over-collected on the emails and documents and used the power of our litigation database to whittle down that volume. So we collected and ingested approximately 297,000 documents. Deduplication then removed around 108,000 documents. And then we ran some targeted keyword searches over that data set and removed any documents which did not respond to that search criteria. And that removed around 172,000 documents, leaving around 16,000 documents for legal review. We then sorted these documents chronologically for the legal team to review, code, and disclose. So let's put the cost around that again. So using the power of the litigation database and our technical skills, ELMS was able to reduce the document set from 296,000 to just 16,000, the legal review time from 2,800 hours to just 271 hours, the cost of legal review from $5,117,000 just down to $48,000. And the cost for ELMS to actually assist on this matter was just under $3,700. And the documents were ready for review within 2 days of ELMS being instructed. And best of all, our client was able to meet their deadline. So the third and final case study is a small matter, which is a PST review. So for those of you who don't know what a PST is, it's an email inbox. In this matter, the law firm received around 5,000 emails on a USB from their client for review, and they needed to provide an advice. So this meant they had a very short time frame for review, and the law firm needed an efficient way to review the documents and remove the duplicates. This was achieved by doing this quick PST review using the litigation database. But before we get further into this case study, I just wanted to take you through some of the risks of importing your client's email inbox into your own inbox and reviewing it that way, as opposed to using a litigation database. So the first risk is altering the metadata of the emails or their attachments. This can be easy to do if you open up an email attachment and save it. This will actually alter the last modified date of that attachment. The second risk is accidentally moving emails from their existing order or original folder. So if you're moving an email to a folder called relevant, or you're actually moving that document from its original position. Another big risk is that not all email attachments will be OCR'd and therefore not text searchable. So if you are running keyword searches, you may end up missing some really important emails and documents. The fourth risk, and probably one of the biggest issues, is that you may actually end up reviewing emails more than once, as it's really difficult to track your review. There's no deduplication functions in Outlook and no analytical tools in Outlook to identify near duplicates or documents with similar concepts. Another risk is you don't get the whole story reading the emails in your inbox, as you can't sort the emails chronologically across all of your email subfolders. The sixth risk is not meeting your client's deadline. Sharing emails and keeping track of who's reviewed what can be difficult using an inbox, and only one person can complete a review from a single inbox at a time. And lastly, and probably the scariest, is that you are dealing with live emails. This means that you have the ability to reply, forward, and delete those emails. So it's not going to be very fun to explain to your client if it goes wrong. So now that we're clear on why you should never do an inbox review in your own inbox, let's recap that case study. So we imported and processed the 5,000 emails received by the law firm into the litigation database. During this process, the deduplication occurred, which removed around 3,800 emails, leaving just around 1,200 emails for review. Elms then did a quick junk cull to locate anything that we knew was not relevant, and this reduced the documents by 230 documents. This left the total number of documents for review by the legal team at just around 1,000 documents. So we ended up reducing the volume of documents by 80%. We then sorted the documents chronologically so that they could understand the story of the documents from start to end, and we did all of this in just under 3 hours of our time. So it was obviously a very cost-effective solution for the law firm and for their client. Okay, so let's talk about the cost around that again. So using the power of that litigation database, we reduced the documents by 80% from 5,000 down to around 1,000 documents, the legal review time from 10 days just to 2 days, the cost of legal review from around 15 grand to just $3,000, and the cost for Elms to actually assist on this matter was just under $1,000, and the documents were ready for review within 1 day of Elms being instructed. And again, the client was able to meet their deadline. So now that we've taken you through the case studies, let's recap the stages of the eDiscovery timeline that we've covered today. Kate took us through the how and why of identifying documents to be collected, and then Sam took us through the collection of documents, how this is done, and what steps should be taken along the way. He then took us through the purposes of a document management protocol, setting up the litigation database, and processing the documents. Finally, I've stepped you through the steps taken in preparing the documents prior to legal review and the strategies that are generally used to reduce the volume of documents. So we hope this has given you a deeper understanding of the eDiscovery process. So we know today's session has been jam-packed with information. So if you can take just 3 things away from this session, let it be these. Number 1, avoid altering the metadata of documents on collection. Spend that extra time to collect the documents properly to begin with, and you will save yourself a whole lot of trouble down the other end. Number 2, engage with your eDiscovery provider and get them to help you reduce the volume of documents for legal review. There are a number of strategies available, and this will again reduce the cost of your storage, which will reduce the overall cost to your client. And lastly, please, please, please do not import your client's email inbox into your own inbox for review. So where possible, process and review the documents in the litigation database. So thanks everyone for coming today. If you do have any questions, please pop them in the Q&A box down below. And just while we're waiting, I'll just hand over to Kate again, just to wrap up the session.
We just have one question that's come through, Kira and Sam. I can answer it, but more than happy for you guys too. What do you do if you can't agree a protocol? Who would like to answer it?
That's a really good question. I think it really depends on what the point is that you're trying to argue about. So if it's something that your eDiscovery provider can do and it's not going to cost too much time or money for your own client, then your eDiscovery provider will probably be likely to encourage you to agree. But if it's something that's going to cost your own client quite a lot of money down the other end, whether it's objective coding, things like that, we would really encourage you to push back. But if you have any further comments, Kate, please feel free to jump in.
I think also that what we would encourage is to get the two eDiscovery providers talking, because that will take the cost of that whole discussion down to a level where you can get it resolved, as opposed to the lawyers going to and forth with their correspondence. So if you just get the eDiscovery providers in a room, I'm sure they can come with a solution. There's never been a protocol that we haven't been able to negotiate to a point where every party is happy and we're not disadvantaging each other at all. So throw it back to your eDiscovery providers and make them negotiate hard for you, is what I would recommend. So thank you all for coming today. Our next session is, wow, really exciting. We're going to talk about who you need to gather, your all-star team for your legal review, and the different strategies you can put in place to conduct your legal review. So there's lots of ways you can do a legal review. We're going to go through all of those particular methods and explain them to you so that you can fully understand what you're dealing with. Thank you all for coming today, and we do know that we have given you lots and lots of information, but if you can just remember those 3 things that Kira asked you to remember, that would be great. And please don't import your clients' emails into your own inbox. Use a litigation database to review them effectively. So thanks, Terry, for your time today, and thanks for getting us involved in this session.
Sure. I had a quick question, if I may, before we close out, to all of you. And as I was listening to this, I was seeing that there's obviously an enormous amount of work that goes in before the review, that I'm going to call it the pre-review, before you actually get down to it. And it's a little bit of a benchmarking question, really, for the folks that are listening to this in a way as well. How do you find, or how ready do you think folks are in terms of their document management strategies or their systems? So some of the stuff we spoke about in the first episode, how ready are they with that, so that you're spending minimal time on the pre-stuff and just getting right into it on say a scale of 1 to 5, 1 being you can go to 0 if you like, not ready at all, and 5 being, yes, we are ready to rock and roll. I just thought folks might be interested to know, where does the average law firm kind of lie in that?
Yeah, that's a really great question, and I'll take that one if you guys don't mind. So Terry, we find that sometimes the really massive organizations, their clients that you deal with, are really unorganized. And then you'll find, the little 2-person company that's being sued has everything beautifully organized in a folder structure that you can easily go and collect, and everything's nice. So it actually depends on the people who are using the systems and whether they understand the importance of it. We have one particular client who's an engineering client, and they are so invested in making sure that extracting documents is easy to collect from and very efficient to help their legal team when they're getting sued, and they regularly get sued. So they have actually got us to go in there and help them develop their system so we can iron out all of the issues of what is your folder structure, where are we naming the privileged documents, how do we export them so that we don't alter the metadata. So there are certainly that end of the scale where those types of organizations are really organized, and then there's some that just aren't. And we still help them with, if you tweaked this a little bit, you might get a better result using this. So certainly we do offer those services to go out and talk to people about how they name documents, how they save documents. But again, that's entirely up to the people that are using the system. So sometimes it's hit and miss.
Yeah, and it sounds like it may be possibly also associated with the incidents with which they've got to keep drawing on these documents and using them for a multitude of purposes beyond litigation, or instead of litigation, I guess, as well.
That's right. And two, if they have to do an internal investigation, so if they have a HR matter and they have to investigate that internally, that's when they really learn what their problems are, because they try to review their emails in their inbox, it's just an impossible process. Or they take them out and they put them onto a network drive, and again, that's an impossible process. So they certainly identify when they're doing their internal claims process where their issues are, And that's often when we get a call to say, oh my gosh, can you please help me with this? I would rather not do this process at all.
Yeah, absolutely. So that upfront kind of discussion, critically important, as well as the process itself. So, well, thanks very much, Yvonne. Thanks for answering my question. And I know folks can find all of you on, obviously, website, of course, but on LinkedIn and Facebook and Twitter, and you'll find us there. And just want to add to what Kate was saying, please do tune in for episode 3, 4, and 5. And you'll be able to catch this one in replay in video and podcast, and also episode 1 as well. So thank you to all of you, Kate, Kira, Sam, and thank you for everyone attending as well.
Bye, everyone.
Bye.
Bye.
Thanks. Bye, everyone.